Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Once again, law of torts, major portion. Right. So, in the law of torts, at the concept stage, I told you what is vicarious liability. So, qui facit per alium facit per se. That means who does the act, he who does the act through another is deemed to have done the act by himself with the relationship. That means principal, agent. Then all of you know master, servant, partner, government, it's servants. So vicarious liability. So in the law of torts, yes, vicarious liability is expected. Please remember, that's why intentionally, fraudulently, all these things should be there. So if vicarious liability is not defined in the particular law, then you cannot fix up the vicarious liability. So this is what happened in this WhatsApp case. Friends, you might have seen yesterday in the Hindu magazine, dated 25th February 2022. In Hindu, it has come that WhatsApp messenger, WhatsApp administrator cannot be vicariously held liable. Kerala High Court. Right? This has been initiated by the courts a number of times. So, while disposing the case of Manuel, M-A-N-U-E-A-L, Manuel versus State of Kerala in criminal miscellaneous petition number 3654 by 2021 on 23rd February 2022, Honorable Justice Kausar Edapati, Kerala name, Kausar Edapati, held that administrator of WhatsApp, so he cannot be vicariously held liable for the objectionable comments posted by the one of the members. He can, what is his duty? He can almost join the members, or he can delete the so-called message. That's all. He cannot be held liable for the act done by another. Right? Please remember here. Better to know the facts of the case. This man, Manuel, he has started a group called as Friends, F-R-I-E-N-D-S. Not the Friends in the ITAct I told you. That was Kerala's government-sponsored organization, SWIFT and other things I told you. But anyway, he has started a group called as Friends. Then, in March 2020, the main accused, that is Manuel, actually WhatsApp administration is A2. Manuel, he has posted some objectionable material in the group. So what is that? It is the sexual act between children. It is a porn video depicting children in sexually explicit act in the group. So immediately this has become viral, and Kerala police, they registered a case against this Manuel, and subsequently our friend, this WhatsApp group administration, he was also charged as A2. So in this connection, this A2 approached the Honorable High Court of Kerala, stating that he is not responsible, and he requested the court to quash the proceedings under section 482 of the CRPC. Right? Actually, the cases, the sections of law, better to know. Sections of law, 67B. So, 67B of the Information Technology Act, it clearly says that whoever uploads any sexually explicit material, particularly relating to children, they are liable even up to, I think, for 10 years. 67B of the Information Technology Act. Yes, definitely that man, the person who posted, he is held liable. Second, section 13, 14 and 15 of the POCSO Act. POCSO Act means Prevention of Children from Sexual Offences Act. Very serious act. Section 29 and 30 of the act, they gives presumptions. That means if at all any case is registered, if at all any complaint comes to the magistrate or the judge, should presume that the act has been done unless the accused rebuts the same. That means the burden of proof shifts to the accused. Of course, these words may be confusing to you. Anyway, so section 13, 14, 15 of the POCSO Act also have been. అంటే చిన్న పిల్లల మీద లైంగిక ఇట్లాంటి దాడి చేస్తే ఈ సెక్షన్ పెడతారు. రైట్. Now, okay, ఇదంతా A1 మీద అయితే ప్రాబ్లం లేదు. Now, the WhatsApp administrator, he is also now figured as A2. Therefore, he has approached the High Court. Right. Now, the question before the court, the primary question before the High Court is whether the creator or the administrator of the WhatsApp group is vicariously liable or is criminally liable for the offensive content by A1. So this thing. So High Court clearly said that WhatsApp definitely the advantage of WhatsApp, now you can find a lot of petitions, a lot of documents, fast communication, lot of voice calls, a lot of video calls, and a lot of material. So you can express your opinion, all these things. So it is the fast growing information technology method which is proved to be useful to so many persons. So the exchange of information, it is quite relevant to the exchange of information in a very fast manner, and it enables the persons to chat and to call also. Suppose if you go to America, then you can contact your relative siblings in India through WhatsApp. Suppose if you want to make a call, definitely the trunk calls are, since we are old people, I am using that word trunk call. Now the charges will be very, very heavy. So instead of that, you can use WhatsApp. Nowadays, we are all using the same. So please remember, for arising the vicarious liability, first of all, the law should permit. So there should be a legal relationship between the people. What is the legal relationship? After all, he is an administrator and this man is only a member. So please remember, vicarious liability comes if there is a statutory provision, neither in the Information Technology Act nor in the POCSO Act, the so-called vicarious liability is not at all mentioned. The sections do not provide the so-called vicarious liability. Therefore, the WhatsApp administrator is not held liable for the act done by the member. The member is definitely liable for the act done. Therefore, the High Court quashed the proceedings under section 482 CRPC. So friends, please remember, this is a very important case as far as the latest young advocates are concerned, because you must have the Information Technology Act on your 2000 on your fingertips, otherwise it will be very, very difficult. Here I want to tell you, IT people can easily understand. WhatsApp administrator is not an intermediary. Who are intermediaries? Simply to say the persons the companies who pass your information from one end to the other. That is like Google or Yahoo. They are the intermediaries, but not the WhatsApp administrator. Anyway, so when I was going through the newspaper, and also I received this in the Ongole Bar Association WhatsApp group. Once again, I received it through WhatsApp. Then only I have read it in Hindu. So I have to convey my thanks to Srivyas Gar, Chitti Venkateswara advocate, who has forwarded the so-called information to me. Otherwise, normally yesterday, since I was away, I could not have gone through this Hindu newspaper. But anyway, luckily this case has come. So please refer this case as Manual versus State of Kerala. If you read the case, definitely you will understand the legal provisions, particularly related to the 67th Information Technology Act, Section 13, 14 and 15 of the POCSO Act, and definitely you will be enriched with legal knowledge. Thank you very much.